Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Wayne Logan, Gary and Celine Pajic Professor of Law at Florida State University College of Law. We will discuss his article, Contracting for Fourth Amendment Privacy Online, which he co-authored with Jake Linford and is published in the Minnesota Law Review. So welcome to the show, Wayne.
Thanks for having me, Brian, and it's nice to meet you online and speak with your listeners.
Yeah, no, I'm glad that Jake helped set this up, and I really enjoyed your timely and interesting article. But for listeners who might not be so familiar with Fourth Amendment doctrine and how it works, I wonder if you could talk a little bit in general about how the Fourth Amendment protects people against searches. In other words, what's the standard for determining whether or not a Fourth Amendment search is permissible, and sort of where did it come from?
Sure. So, of course, the Fourth Amendment's in the Bill of Rights, and initially it regulated only federal law enforcement agents. But over the years, the U.S. Supreme Court has held that, in fact, the Fourth Amendment also regulates state and local activities of law enforcement agents, and it prohibits unreasonable searches and seizures. And so a threshold question always has to be asked is what the police are doing, whether it constitutes a search. And over the decades, the Supreme Court has had several approaches to it. In 1967, the U.S. Supreme Court handed down its important decision in the United States versus Katz. And in Katz, the question before the court was whether, in fact, the police use of a listening device to the top of a public telephone booth qualified as a search. And defendant Katz was allegedly speaking over the telephone line, engaged in illegal betting interstate. And so federal agents got that information, and they used it to prosecute Mr. Katz. So the question, again, before the U.S. Supreme Court was whether, in fact, there was a search, because only if it's a search, again, the very terms of the Fourth Amendment only regulate searches and seizures, only if it was a search would the police be regulated and subject to the Fourth Amendment. And the Supreme Court, in a very important decision, decided, yes, in fact, it was a search, even though the police didn't physically penetrate the telephone booth. You know, just as an aside, these days when I teach Fourth Amendment criminal procedure matters, I have to put up on the screen an actual picture of a phone booth, because many students these days don't realize what a phone booth is. And I have to say that that's what Superman jumped out of wearing his cape. So the physical aspects of a phone booth are important, but the point was that the police didn't penetrate it physically. So that was important for the court, because up to that point, the court kind of looked at whether, in fact, a search occurred was whether the police engaged in what's called a trespass or a physical intrusion. And they didn't, again, in Katz. So in Katz v. United States, the Supreme Court handed down, created a new test, basically, that said whether a search occurs when the police invade what is called a reasonable expectation of privacy. And this actually kind of came out of the concurring opinion of Justice Harlan, but it became the Katz test. And so there's two questions with whether a reasonable expectation of privacy exists with a person. Number one is whether the person indicates subjectively manifests an expectation of privacy. So in the Katz case, Mr. Katz manifested his subjective expectation of privacy by closing the phone booth and putting the dime in the phone booth. To be sure, the phone booth was transparent, but as the court wrote, what he sought to protect was not the uninvited eye, but the uninvited ear. And that ear, of course, was the listening device that was on the outside of the booth. So the first test of the new Katz test, first prong of the Katz test was satisfied. Again, he manifested his subjective expectation of privacy. The second question in the Katz test was whether, in fact, that expectation, that subjective expectation the individual has, whether it's reasonable, whether it's objectively reasonable. And that usually is the most significant part of an analysis the court undertakes. And there, too, the court held that Mr. Katz had an objectively reasonable expectation of privacy, that when he shut the phone booth there, he didn't expect people to be overhearing his telephone conversation. So it's a very important decision in 1967, and that rule really has decided many, many cases in the decades since. And so in the Minnesota Law Review article, again entitled Contracting for Fourth Amendment Privacy Online, Jake Linford, who, by the way, is a colleague of mine here at FSU Law, we teamed up. Now, Jake is a contracts professor, private law, and I'm a criminal procedure person, public law. And so we thought there might be something worthwhile to discuss with respect to the intersection of private contract law and public Fourth Amendment law. But we can get into that later in our time together. But just for starting purposes, that's what a search is. It's when the police invade a reasonable expectation of privacy.
Mm-hmm. So just to really clarify, then people are protected against searches by the government, by the Fourth Amendment, when they believe or they have a personal expectation that things are going to be private. And we think from some sort of objective outside perspective that the belief or expectation of privacy that they have is reasonable under the circumstances.
And that's exactly right. And so, and usually that second prong of the two-prong test is whether it's objectively reasonable, and that's decided by courts. And that facet of the test in particular has generated controversy over the years. Conservative members of the Supreme Court will critique that part of the test because saying essentially it's judges saying from on high that what is objectively reasonable and what's not. But yes, that's correct. And so if it is a search, the police have to get a search warrant, or they have to have an exception to the search warrant. So for instance, consent. So for instance, if a police officer wants to walk up to me and look in my backpack and there's no warrant, or they would have to ask for my permission, provide my consent, or have some other kind of extenuating circumstance. So the key thing, again, the threshold question is whether it's a search, and that's where the test comes from.
Well, so one aspect of Fourth Amendment doctrine that's been kind of in the news and controversial in recent years is the so-called third-party doctrine, which is really I think a big part of what your paper is sort of wrestling with in a way. I wonder if you could talk a little bit about what that is and how it works in relation to the concept of a search under the Fourth Amendment.
Right. So the third-party doctrine is very important, and it originated actually a little bit before Katz in 1967. But the gist of the third-party doctrine is that a search doesn't occur if, in fact, the third-party doctrine applies. And so this is the third-party doctrine. It's basically when it is believed that a person voluntarily turns over or exposes information to a third party. And so there were several Supreme Court cases, but one particular one was when an individual turned over bank records, provided records to the bank, and the law enforcement went and got those records without getting a warrant. And the question there was whether, in fact, that was a search. And the Supreme Court held in that case, similar to other cases, that the individual in that case, the defendant, didn't have a reasonable expectation of privacy because he gave this information to a third party. So it's a form of consent in a way. Now, even though in that case, Mr. Miller, the bank records case, he had an expectation of secrecy. He may have not thought that the records would be seen by anybody else except for the people in the bank. The court held that it was not a search because he didn't have a reasonable expectation of privacy with respect to those records. So that's the third party doctrine. And so that has decided a lot of cases over the years. And as you mentioned, it's become more controversial over time, in significant part because so much of our social and political existence and commercial interactions take place online. And so when we engage in search activity on the internet, for instance, or frankly send an email to somebody, there's a third party involved. There's going to be a carrier involved with respect to an email, or there's going to be some entity, the cloud or some computer, internet aspect will essentially be reposing that information. So in an interesting case a few years ago, United States versus Jones, the question before the U.S. Supreme Court was it a search when the police put a tracking device, a GPS tracking device in Mr. Jones's car, and they tracked it for roughly a month? And the U.S. Supreme Court unanimously held that it was a search, so therefore the police had to get a search warrant. But an interesting concurring opinion, Justice Sotomayor said, you know, this is really not the case for it, but I want to say that I'm concerned about how the third party doctrine, again, this idea that when you disclose information to a third party, you are essentially disclosing it to the police, how that, you know, is affected by the internet. Because, so for instance, on your home computer, you may be, you know, searching all kinds of things and none of it illegal, but it can be sensitive issues, you know, reflecting WebMD web searches and things of that nature. So she kind of, you know, fired a kind of a warning shot in this concurring opinion. And so fast forward to 2018, the U.S. Supreme Court in the Carpenter decision dealt with a similar issue. So in the Jones case, as I just mentioned, the police physically attached a tracking device on Jones's car, and the court found unanimously it was a search. In this case, Carpenter, what the police did was that without a warrant, they got geolocational information from cell phone providers, the towers that are used to track and enable individuals' use of cell phones. So the question there was not physical attachment of a device, but whether in fact, simply because these records were held by Verizon and Sprint and companies like that, a third party again, just like the bank records, whether in fact the third party doctrine would say, I'm sorry, Mr. Carpenter doesn't have a Fourth Amendment right here. He doesn't have a reasonable expectation of privacy in the geolocation data wherever he went from point A to B to C to D to E over a period of time. And the U.S. Supreme Court again held that this was a search, and a more fractured decision, a divided court. And they held that the third party doctrine doesn't necessarily determine here that the fact, whether in fact Mr. Carpenter had a Fourth Amendment right, that the majority held that in fact there was a Fourth Amendment right in that situation. So this Carpenter decision is important. The court was careful to say we're not doing away with the third party doctrine, but basically the court said with respect to these data, this tracking information, these records, it's not a third party doctrine case. So he had a Fourth Amendment right, Mr. Carpenter did. So that's a roundabout way of giving you an answer to what the third party doctrine is. And there's reason, again, scholars have criticized it repeatedly over the years, and now there seem to be some cracks in the wall in the Supreme Court with respect to whether this third party doctrine is going to continue.
Well, so Wayne, one thing that's been confusing to me, and I don't know if there's a good answer to this or not, but like, how does the third party doctrine work in relation to the two prongs of the Fourth Amendment analysis? In other words, is the third party doctrine saying that people don't have a subjective expectation of privacy when it applies, or that it's not objectively reasonable for them to have a subjective expectation of privacy? Or is there like something totally different going on that I'm not understanding?
Well, I think you've kind of identified, you know, one of the criticisms of it, which is that it's rather amorphous. It's just simply that you don't have, you know, from on high, you don't have an expectation of privacy because you're sharing it with somebody else, and that by definition is objectively unreasonable. And the focus of this article, if we want to shift to the focus of the article, so what we're doing here is kind of in the internet ecosystem, so to speak, in the online world, where we share so much information. You know, a moment ago we were discussing how when you do internet searches, it reveals information about yourself, not about illegality necessarily, but personal information. It may be querying a political group or something like that. When you're in the online world, social media obviously is really important in terms of service agreements and privacy settings and things of that nature potentially come into play. And obviously Facebook is enormously popular and plays a central role in modern social and political life. And so that's a main focus of the article, that, you know, so again, if you apply strict third party doctrine, if I have a Facebook page and I have one friend out there, that by definition would say that I don't have a privacy right because I'm sharing that information with somebody else. Now, you know, as people have pointed out, the third party doctrine has a lot of weak conceptual foundations. For instance, you might say, well, in that famous Katz case in 1967, the telephone company could have been listening in on Mr. Katz's phone call. And if that's the case, then he doesn't have a privacy expectation that, no search would have occurred. So by the same token today, simply because I have one friend on my Facebook posting, on my Facebook page, by virtue of that, if you have a strict application of third-party doctrine, you would say the person doesn't have a Fourth Amendment right. So the police can go in and access that without a warrant or consent or an exigency or anything. They can go in and get that information. And so the virtual world has complicated the third-party doctrine in ways that wouldn't have really been predicted back when it first was created back in the 60s and 70s.
Yeah, I mean, it seems like given the way the technology works, there's sort of a third-party proxy for almost all information that we end up communicating, whether or not we're even realizing that we're communicating or even creating maybe that information in the first place.
Yeah, exactly. And so, back to Justice Sotomayor's concurrence in the Jones case, the GPS tracking case, she urged that there should be a difference between secrecy and privacy. Simply because something is not secret per se, like the bank records we talked about a moment ago, doesn't mean that a person should lose a privacy expectation. And I personally think that's an important recognition to keep in mind as we go ahead when so much of life occurs online in the virtual reality. And so that's kind of what the article tries to address. And one of the problems here, of course, is that there can be a real chilling effect, which is something Sotomayor also mentioned and addressed in her concurrence, that if in fact we're so paranoid about law enforcement eavesdropping on our social media accounts and things of that nature, that could certainly could chill social life, but also political discourse, which is really an important outgrowth of the Fourth Amendment. Because if people don't feel as if they can communicate freely with one another, that obviously has First Amendment impact, and also just with respect to general political discourse, it's problematic in that regard too. So that's why we felt it was important to try to see if we can kind of infuse some of the Fourth Amendment doctrine with contract law in this particular context. And what we found out when we reported on the article, there's kind of two parts to this article. The first part was descriptive, and we looked at kind of a surprising number of courts have been wrestling with this issue of the contractual aspects of online life. And we saw a surprising number of courts were certainly at least acknowledging privacy in settings, terms of service agreements, and things of that nature when they're trying to assess whether a person has a reasonable expectation of privacy. And that's important in itself because, again, if you take a strict third-party doctrine view on social media, for instance, there wouldn't be any Fourth Amendment privacy rights. So we kind of say that the third-party doctrine is kind of being hollowed out from below by these state and lower federal courts and these decisions we talk about in our article. So that's the descriptive part. And then what you might call the prescriptive part, we shift to say how we look at how contract law can perhaps provide a meaningful and attractive alternative to the Katz test, which again itself has been criticized over the years as been too indeterminate and kind of too open-ended about what should qualify as a privacy right.
Well, on one level, it seemed to me like the paper was almost advocating more emphasis on subjective expectations of privacy, given the kind of atomistic, heterogeneous way that internet services end up working. And almost seems like it was suggesting that, or arguing that the relationships that people have, both contractual and contextual, with different internet service providers might provide us with information or at least clues about what kind of privacy people using them expect to have.
Yeah, I think that's absolutely right. And it's all playing out against the backdrop of what is reasonable under the circumstances. And I think the courts, this kind of body of case law that is developing, decisions in this realm are still being issued, of course, wrestling with these issues, is they're willing to look at the third-party doctrine in a critical way that you don't see courts doing in the past, and a way similar in the Carpenter decision by the U.S. Supreme Court. Simply the prospect that somebody else, law enforcement might be able to see it, doesn't cancel your Fourth Amendment privacy right, and that's an important shift with respect to orientation. It's not a very there's a movement now afoot, and we're seeing it in these courts here, where they're willing to take a more critical view of this really kind of traditional doctrine that, as I said before, cancel people's Fourth Amendment rights in many different contexts over the years.
Well, so, I mean, in practical terms, what does that mean? I mean, like, if courts are trying to determine whether or not someone has a reasonable expectation of privacy in a particular circumstance, what might they look to determine whether or not that's the case? I mean, you talk about the kind of relationship to the internet service providers. What about that relationship might or might not provide clues about people's reasonable expectations?
Yes, so it's a rather complicated question because so again, there are privacy settings. That's one aspect where I can manifest my subjective expectation of privacy, to follow up on your earlier question. And then there's behaviors. And with respect, if an individual is behaving in a way that's contrary to what they're signaling, that obviously can complicate the analysis. So let's just start out, that I have a kind of a narrow privacy setting, again, Facebook. And then the website design indicates that I have a privacy interest they're going to protect. And then down buried in the boilerplate, it indicates that they're going to, freely share information with the police. So it can be a complicated question as to whether, what to honor, at what point to honor. But one of the things we're trying to do in this paper is to sensitize people to users of social media in particular, or engaged in the online environment, the importance of some of the contractual kind of private law aspects that are at play in these particular situations. And of course, there's what is known as a privacy paradox, where people say that they want to protect their privacy, but they don't necessarily behave in a way that's consistent with that. And so, one of our goals in this article is to again, just to sensitize people to the importance of reading these documents, the agreements, to the extent that they can be understood, and also how they comport themselves in the online environment, and also with respect to their privacy settings.
Well, one takeaway that I had from the article really was that there's this interesting disconnect between, at least in some cases, what the kind of supposed contractual or maybe actual contractual relationships between internet providers and their customers are from a contractual standpoint, as compared to what consumers or users perhaps understand that relationship to be. Like, they aren't always 100% communicating exactly what kind of legal restrictions they're placing on themselves in relationship to their users.
Yeah, absolutely. And so, it's kind of what might be thought of as a trust-based design kind of context. And so individuals can be lulled into a false sense of security with respect to the privacy of their interactions online. And that's, there seems to be evidence to support that that's kind of part of the business model. And again, that can have a really negative effect on social discourse and democratic interactions. If people are, behaving in a way that they're being kind of lulled into a false sense of privacy security, so to speak.
I mean, I get the sense that, like, in some circumstances, these internet providers want to reserve to themselves the ability to use certain kinds of data in various ways if they want to. And it seemed to me that you were suggesting in the paper that perhaps the mere fact that the companies have structured their relationship with their customers such that they may have access to and the ability to use data under certain circumstances doesn't necessarily mean that the consumers don't have a belief that some of that data is still private. Is that right?
Oh yeah, absolutely. Yeah, and again, of course, it operates in many different levels. So, for instance, the New York Times has had an interesting and important piece on tracking of physical movements by virtue of telephones, right? And people would do that. People are oblivious to that, but those are data, and very often the data are monetized by companies. And also, there can be obviously, important ramifications with respect to, law enforcement and democratic governance as well. Yeah, so there's increasingly, even in the context of course, the First Amendment only regulates government action, but Facebook is a big player with respect to regulating content of online speech, and so we're seeing a real shift now because, again, it's a function, large part of the fact that so much of life is online, that there's a kind of a privatization of the First Amendment in a way. And so in this article, Professor Linford and I try to highlight that there's a privatization of the Fourth Amendment in part here, as indicated by these courts. So we think it's a useful contribution to where things stand. And again, we'll see. It may be the case that the U.S. Supreme Court will do away with the third-party doctrine, as many people urge, but that's not indicated by the most recent pronouncement from the court in Carpenter in 2018. Again, the cell site location information case where the court said that essentially said that the third-party doctrine didn't apply.
So, can you talk a little bit about why you think this approach is preferable to alternative approaches that others might have suggested? Is it because you think it might help us track more closely people's subjective expectations of privacy, or for some other reason?
Yeah. So, in part of the article, and significant part, is framed as what we think is a useful alternative to cats, or at least a kind of augmentation of cats in this context, where we'll have a better, kind of more concrete way to assess Fourth Amendment reasonable expectation of privacy, both with respect to both prongs of the CATS test. Number one, the subjective manifestation, and also importantly, the second prong. So again, simply because I'm friends with you on Facebook doesn't necessarily, which again, and I limit the extent of my friends, well, that's a subjective manifestation of privacy. But with respect to the second prong, simply because I'm willing to have you as my friend and interact with you doesn't necessarily mean that I'm also amenable to police having access to this information and that they could get this information without a warrant. So in that way, we think it's a positive step forward. This so-called privatization of Fourth Amendment law, kind of infusing Fourth Amendment law with contract law by making it more, allow for a more systematic and objective analysis for courts to undertake when they can look to contract law for what a person expects is going to be private, and relatedly, number two, what society should consider is reasonable for a person to expect. I mean, we honor contract terms all the time, obviously, in commercial interactions, and we say that, there's a role for that here in the Fourth Amendment context as well, as opposed to, again, the CATS test, which has been criticized as being far too kind of normatively driven by judges. And, some it might say, one criticism would be is that, essentially this privatization of Fourth Amendment privacy expectation, again, is problematic because it's going to be too individualized. Well, as we point out in the article, the reality is that Fourth Amendment rights are not equally distributed. A person who lives, in a single family house behind a a large fence has more privacy, frankly, than a person who lives in a multi-dwelling unit. So the idea that Fourth Amendment rights are equally available throughout society is not true as just a descriptive matter. And so on here, the idea is that if you can engage in an arm's length contractual negotiation or understanding with Facebook or whatever the entity might be, that there might be some value to the autonomy that is associated with that. And again, this is predicated on the idea that people know what they're doing. People tend to be overconfident, certainly myself included, with respect to the tech savviness. But again, as I said, one goal in this article is to highlight to people the importance of these contractual relationships that are playing out online. It's the importance in significant part lies in the fact that courts are looking at them now to try to figure out whether a Fourth Amendment right is at play in this online context.
Well, so Wayne, in closing, your and Jake's article focuses on kind of thinking about expectations of privacy in the context of the Fourth Amendment and rights against intrusions by the government. I wonder if you think it might also have some helpful insights or potential in thinking about privacy interests more broadly, both in terms of kind of governmental positive regulation of privacy interests and also thinking about the relationships between consumers and the companies that are providing services to them, irrespective of the role of the government.
Right. And again, this is this idea of private ordering of constitutional rights is, admittedly a interesting and emerging issue. But I mean, part of the idea here is that with this greater sensitization, will be a leveling up. That individuals who are sensitized to the privacy ramifications of terms of service agreements and privacy settings, things like that, they're going to demand and expect more from the internet providers. And hopefully there'll be a leveling up that all people would benefit from. And of course, if a person wants to opt out of a privacy right, that's certainly their prerogative. But what we're trying to suggest in this article is that there can be a place here for private law with respect to courts assessing whether there's a public Fourth Amendment right in a particular situation.
Great. Well, Wayne, thanks so much for coming on the show. This was a fun conversation, and I really enjoyed reading your paper and talking to you about it.
It's my pleasure. Thank you so much. And happy holidays.
Likewise.
Dancing in shopping centres, bargains galore on Remembrance Sundays, raining cabbages and church-like sales, children with chainsaws and Catholic boutiques, homemade desires and vegetable antiques.
Part 1. Fulfilling the contractual obligation.
Indian ice cream parlour houses, melancholy pussycats playing with mouses, happy-go-lucky undertakers, tree-lined bungalows, marzipan flavoured, postmen toying with Lucasade fetishes, police screaming laughing at the unemployed, ecstasy houses for the hard of hearing, Muslim fickers like to get the beers in.
Part 1. Fulfilling their contractual obligation.
Mowers dancing in a rude formation, animated talks with bilingual Alsatians, flying nuns shopping in DIY whorehouses.
Part 1. Fulfilling the contractual obligation.
The grand old Queen of York, he had 200 men. His case comes up in court on Tuesday morning.
Part 1. Fulfilling the contractual